Freya, are we ready?
Ready?
Good morning. It is the second regularly scheduled docket of the Oil Conservation Division. This docket is for status conferences, protested cases only. We have a couple of motions to deal with as well for some of the cases here, but let's get on the record with case numbers 1, 2, and 3. Matador Production 26005, 6, and 8. Entries, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant MRC Permian Company.
Thank you.
Good morning, Mr. Examiner, Dina Bennett on behalf of Avant Operating 2 LLC.
Good morning. I have received a motion filed by Ms. Bennett. Ms. Vance, I know that it was just filed yesterday, and
I can add some more color. So actually, we just filed a motion to dismiss our own cases. We just filed it this morning, like literally 5 minutes ago, so you wouldn't know. So there was, we had a discussion at the last status conference. There were some title issues at this point. Matador is going to be sending proposals to Avant, and we'll file applications in the future if necessary. But we did just file a motion to dismiss.
all right, thank you. Freya, have you received those?
I just checked the queue. They're in there waiting to be processed.
Anything further, Ms. Bennett?
Nothing further.
All right. Thank you, Ms. Vance. Thank you, Ms. Bennett. We're off the record in those 3 cases. Let's move on to Matador Production case numbers 26057 and 58. Entries, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant MRC Permian Company.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating, Concho Oil and Gas, and Mongoose Minerals, monitoring only.
Thank you.
And Jackie McLean on behalf of Permian Resources, and we have objected to these cases.
Thank you. Thank you. I appreciate that. Ms. Vance, when did you file these cases?
We filed them on March 24th for the May 7th hearing. And I will say that Ms. McLean and I talked this morning. So she's aware we're going to request a contested hearing date. Either, I know that there were some dates circulated, but we would like to request either late July or early August, which I think we'll leave it to Ms. McLean to talk about her side, but that's what we would request.
Before I go to you, Ms. McLean, Freya, what do we have for late July?
July 28th.
Thank you. All right, so we're considering July 28 right now, Ms. Vance. Ms. McLean.
Yeah, so I did talk with Ms. Vance, and it was my understanding the parties were negotiating in that we had wanted to set another status conference in June because if things were not going to work out, we were planning on sending out competing well proposals at the end of June and then progressing forward, towards a hearing date. I don't think based on that timing, I don't think that we would be able to have a hearing on this until August. And I told Ms. Vance we would be okay, setting it for August with the hopes that things are resolved.
Okay.
Can I add a little bit of color?
In just a moment, let me think.
Thank you.
Ms. Vance.
So one of the reasons why we are trying to get to a contested hearing or at least have something set is because Matador has lease expirations. And so we don't want to let this sit any longer than it needs to.
Okay. Ms. McLean, so August would normally be okay with me because that's only 5 months from when the cases were filed. based on what Ms. Vance just said, though, there's more of a time constraint than normal. So if your cases were noticed for July, you could file them even as late as June, middle of June, even late June. We could notice them specially. We could send out a special notice for the July 28 docket. That still gives you. So, I mean, I think if you are, I understand you're negotiating, but if your client would send out the proposals soon, like in the next week or two, I think you'd be okay for the July 28 docket. What do you have to say?
I don't think they're in a position to send out well proposals within the next, because I talked with them at length about that yesterday. And really, later June is due to lots of different reasons. That's the earliest they're going to be able to do that. So they've got their own lease things going on.
Well, Ms. Vance, I can only do so much to get this to a hearing as quickly as possible. I want to get this to a hearing for your client. It's your applications. You filed them in March. I can't force them to file earlier than they're able. So I could set it for early August, which I think would allow.
That would be fine.
That'd be okay.
Yeah.
Freya, do you have anything in early August?
Unfortunately, our first date in August is August 18.
That doesn't work.
Freya, why is our earliest August date 18?
We could potentially do August 4th. However, there's an OCC rulemaking that has
Right.
reserved the room. And then the following week is the WQCC
Oh, that meeting. Yeah.
meeting.
Well, we can use the conference room upstairs if needed. Is the August 4, is that the regular docket, or would that be the 6th?
6th. The 6th, I believe, is the regular docket.
Freya, what
Yes.
if we just add it to the 6th? Would that can be virtual?
It may be if the OCC is still in their rulemaking.
All right. What if we just add it to the 6th? I mean, the parties will probably settle this matter between them at 90% of the time they do, and we go through all these somersaults for nothing. Why don't we just add it to the 6th?
You're asking me?
I'm sorry, what?
Are you asking me?
I am asking.
Oh, yeah, that's fine.
All right. So, Ms. Vance, Ms. McLean, August 6th?
And then to continue to the 7th.
Sure, of
Okay.
course. And as long as we need to, I mean,
Yeah, I think I just need to double check that my client is available that day. And then I can email.
I'm gonna issue a pre-hearing order for August 6th. If that for some reason doesn't work, let us know as soon as possible. We'll adjust it as need be, but I am trying to be considerate of Ms. Vance's client as well as yours.
Thank you. I appreciate it.
Anything else, Ms. Vance?
No, and I'm confirming on my side
Of course
that
you are.
those dates work. Thank
If
you.
if you hear something before the end of the status conferences, we can adjust it in real time.
Perfect. Appreciate it.
And Ms. McLean, with you and your
Nothing.
client.
Yeah, okay.
Yeah.
I'll email them right now.
Yeah, that'd be great. I appreciate
Okay,
it.
thank you.
All right, we're off the record in those two cases. Let's move on to Powderhorn Operating 26061.
Morning, everyone. Ben Holiday on behalf of the applicant Powderhorn Operating.
Good morning.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of MRC Permian Company, and we are objecting. We did send out counter proposals. Those went out on April 30th. And so we could, I'm not sure what Mr. Holliday's position is for Powderhorn, but we do plan to file competing applications.
Thank you. Mr. Holliday.
Yes, I should have taken the opportunity last week to speak to Ms. Vance about this. My apologies. The Powderhorn position is that they would prefer to go ahead and get this set on the docket for a hearing.
Sure.
And August 18th date would work for us.
Okay, that's fine with us. So we'll issue a pre-hearing order for August 18th, and if the parties have a problem with that, let me know. Ms. Vance, anything else?
The only thing I would add is we would be open, if Mr. Holliday is open to it, is another status conference in July. I understand that they want to set a contested hearing, but if we could also do just a follow-up to see where the parties are in July, it would be appreciated.
What we can do is once you file your application, maybe you could file a motion to join it with Mr. Holliday's case. We'll hear your application, I think, in July, right?
Yes, I would be filing it for
And then we'd have a status conference then, if that works.
that works.
And then we'll call Mr. Holliday's case at the same time.
Mhm.
That would work.
Yes.
Mr. Holliday, does that work for you?
Works great.
Okay, so Mr. Holliday, I assume there's no objection to joining Ms. Vance's application when she gets it filed to your case?
No objection.
All right. So then we'll issue a pre-hearing order for August 18th.
Yes, sir.
All right. Anything else, Mr. Holliday?
No, sir. Thank you.
All right. It was good seeing you at the conference.
Yes.
Thank you. Ms. Vance, anything else?
No.
Yeah, I'll say something about the conference. I know a lot of people in this room had something to do with that conference. And I attended Monday's Law of the Colorado River. And after spending a few hours there, I really can't say enough good things about the Law of the Permian Basin. It was well thought out. It was very educational. So yeah, thank you. Okay, we're off the record in that case. Let's go on to Coterra Energy. Looks like we have 4 cases here, 26062, 3, 4, and 5. Entries, please.
Good morning again, everyone. Ben Holliday on behalf of the applicant, Coterra Energy.
Thank you.
Good morning, Mr. Hearing Examiner Caitlin Luck for Avant.
Thank you.
Good morning, Mr. Examiner. Carrie Hatley, entering your appearance for COG operating, and we are monitoring only.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of MRC Permian Company. And we entered an appearance in case numbers 26062 and 26063, and we are monitoring only.
So then who objected?
This case was actually is set. We have a pre-hearing order for July 28th. And so I was a little unsure why we got set for a status conference, but here we are.
And to answer your question, Mr. Hearing Examiner, Avant objected.
Yes.
Okay. So Ms. Luck, did you file competing applications?
Yes, Mr. Hearing Examiner, and those are noted on the joint cases as case numbers 25996, 26129, and 26130.
I see. All right. Thank you. Well, Mr. Holliday, that's your answer.
Yep, there we go.
Did we, Miss Luck, did we join your cases to the pre-hearing order?
Yes, sir.
Okay, fantastic. Mr. Holliday, anything else?
No, sir.
Do you know if the parties are getting closer in negotiations at this point?
I don't know.
Okay.
That does give us plenty of time to work something out if there's a deal to be worked, but I have no information right now.
All right. Ms. Luck, do you have any information?
I'm sorry, I actually don't have an update from Avant, but I will check with them to see if there's an agreement in the works.
That's okay with me. We're set for July 28th, and We'll see how that goes. Anything further, Mr. Holliday?
No, thank you.
Ms. Luck?
No, thank you.
All right, we're off the record in those cases. Thank you. Let's move on to Devon Energy 26081.
Good morning, Mr. Hearing Examiner. Darren Savage with Aberdeen Shield appearing on behalf of the applicant, Devon Energy Production Company, LP.
Good morning.
Good morning, Serafina Sluha on behalf of Matador.
I'm sorry, I didn't hear anything you said.
Good morning,
Would-
Serafina Sluha on behalf of Matador Production.
There we go. All right, thank you. Would you spell your name for the record?
Yes, SERAFINA. Last name SELUJA.
Okay, and you're representing Matador, you said?
That is correct, and we have withdrawn our objection.
Thank you. That's helpful. Appreciate it. EOG? No? Mr. Savage, any indication of EOG and their position?
If I recall, last they were monitoring, that's all I know.
So the only objection, Mr. Savage, was Matador, which is now gone?
That's correct.
So do you want to move your case to the next hearing by affidavit docket?
Yes, if that'd be great if we can move it to whatever the earliest convenience of the OCD.
Sure, I think that'll be June 4. I know that because we have contested hearings on the 2nd, the June 4 docket will be somewhat more limited than usual. But that being said, we'll try to get your case toward the beginning of that docket.
Okay, I appreciate that. It should be pretty straightforward.
Okay, so would you continue your case there, and Freya, will you make a note to try to get that case toward the front end of that docket?
Yes, I will.
All right, anything further, Ms. Saluja?
No, thank you.
Mr. Savage?
No, thank you a lot.
We're off the record in that case. Let's move on to XTO Permian, 2 cases, 26089 and 90.
Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak appearing today on behalf of the applicant XTO Permian Operating.
Good morning, Mr. Suazo.
And Jackie McLean, representing Permian Resources.
Thank you. Ms. McLean, your position?
We have objected.
You have objected?
Yes.
Okay. And what's your intention here?
Our intention is that we are in talks with XTO, but this one is interesting because they actually filed an objection, they actually filed an application just for approval of a non-standard spacing unit. We had objected to their administrative application, so now they're requesting a hearing on that. We are going to be filing a pooling application that's going to compete kind of with that, but it's for a standard space. Ours is for a standard spacing unit. So our plan is to file those for the July docket. And then we think because the parties are in discussions, perhaps we can just have a status conference after they object to our applications in July and then set a contested hearing at that time.
Okay, thank you, Ms. McLean. Mr. Suazo.
Sure. Thank you, Mr. Examiner. I have not received any updates from the client that negotiations are ongoing or that they have even been fruitful. As Ms. McLean mentioned, there was an objection to our NSP administrative application, and then there were 30 days thereafter for the parties to attempt to come to some sort of agreement. They could not, and we would like to get this set for hearing as soon as possible because we have a spud date scheduled in August. And so I think any further status conferences under these circumstances would only be prejudicial to XTO.
Okay, so these two, tell me a little bit more about these 2 applications. They both say ENSP. Why did you file them?
Well, we filed the NSPs obviously to try and get them approved administratively. It's our it's our perspective that our proposals are better. You know, we're proposing 3 mile laterals. It's our understanding that Permian would be filing, 1 to 1.5 mile laterals. And so I think, they'd also have to force pool, and we would not have to force pool any other parties. So I think, our applications are stronger just on the face.
Okay. Ms. McLean, you had mentioned that you were filing competing applications, but you were filing them when?
They should be on the July docket.
Right. When will you be filing them?
Before the deadline for that is
Early
June
June.
9th. So
Okay. Before that.
before then, yes.
So, Mr. Suazo, if Permian files their applications in early June, we could have a July hearing, contested hearing on those. Freya, what are the available dates in July?
July 7 and July 28.
July 7 and July 28. Okay. Well,
Sorry, are you
yes, go
asking
ahead,
me?
Mr. Suazo.
Yeah, the preference would be July 7th, most certainly. I'm actually out of the country on July 28th.
Okay.
And we are not available July 7th.
We're gonna have to find another date in early July. So Freya, let's be.
Might I add something
Yes.
for color here?
Color is good.
And I think there's a lot more at play than just them having this like spud date in August, which is their decision. The reason that we are objecting to this is because XTO's development is going to strand our state lease and our state acreage because this is in the potash area. So there's drill islands and we can only access it from a certain space. XTO's lease is their acreage is all federal. So the state of New Mexico, is a party here and very interested in what's going to happen. And so we are currently talking with them as well about this acreage being stranded because the state land office wants this to be drilled. So that's why we're asking if we can push this out a little bit further. They don't need to have a hearing for an August spud date. In July, they can wait, or they can grant us an easement on their acreage to access the drill island. So because there's multiple entities, multiple parties at issue here, we're asking that this be pushed out a little further so that we can coordinate, because as you know, all these different agencies, it's not like stuff happens super quickly. So that's why we would, hope that we could maybe push it out towards August a little further, or in August.
Mr. Suazo?
Yeah, I just, don't really agree with, Ms. McLean's characterization. That being said, I haven't received feedback from my client as to the potential for granting an easement. That sounds workable. And if that is workable and acceptable to my client, I would suspect we could get that put together fairly quickly and continue, on the calendar for sometime in July, even if it's a special hearing docket in early to mid-July. And, I think that would be something that my client would entertain, but I would need to get their feedback before confirming that to the division.
I'd like to just add one more thing too. I mean, whether we have a contested hearing in July or August, we're not going to get an order because we're still waiting on one from October. So I think that, they should have filed earlier. That's kind of their fault if they wanted to spud in August. But we really think that the parties should be given time to work this out. And hurrying to this hearing where we're not even going to get an order until like December is not necessary.
And if I can just respond to
Yes,
that,
go ahead,
it's not XTO's fault that, Permian acquired a lease that's on a drill island. We already have a drill island. We're ready to drill. So, we just don't want to be held up any longer than is necessary.
All right. I understand. Okay. Freya, you said we had the 28th of July, didn't you?
Correct.
All right, which is almost August. Ms. McLean, how do you feel about July 28th?
I'm fine with that, but I think Mr. Suazo said he's out of the country.
Well, if we want to put it on the calendar, we have a big enough team over here to where we can probably have that covered, or I can, call in, if possible.
Right, okay. Okay, that'd be fine. And most likely you'll work it out. So, okay, so we'll issue a pre-hearing order for August 28th. If you need more time, let us know. These dates are movable with a good argument and with some evidence to back it up. So that's what we'll do. Mr. Suazo, anything else?
Just to clarify, you meant July 28th,
That is what I meant. What did I say?
August.
I'm sorry, sir. I
Okay.
do mean July 28th, yes.
Okay, thank you, Mr. Examiner.
You're welcome. Ms. McLean?
Nothing from us.
All right,
Thank you.
Yeah, good luck on your easement. All right, let's go on to Paloma Permian. This is 26093. Entries, please.
Good morning, Mr. Examiner, Dina Bennett on behalf of Paloma Permian, and we filed a notice of dismissal of this case yesterday.
Thank you. Okay. I know I signed something about that yesterday and I forgot that I did that. It's still here on the docket. All right, let's get to the last juicy case that we have, and this is this is the famous Select Water Solutions. This is one of 4 cases that was filed quite some time ago, but I think December, if I'm not mistaken. This is 25899. Entries, please.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Select Water Solutions.
Good morning.
Good morning, Mr. Hearing Examiner. Pete Domenici on behalf of the City of Jowl.
Thank you.
Good morning, Mr. Examiner, Dina Bennett on behalf of Coterra Energy Operating, and we have objected to the case moving forward by affidavit.
Thank you.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Devon Energy Production Company, and we are monitoring only.
I don't see Devon on our list here. Oh, I do see it. Holland Hart representing Devon. Yep. Thank you, Ms. Vance. So you are monitoring. Ms. Bennett, you objected, and we have a hearing scheduled for just, I don't know, a couple weeks from now on the 2nd of June, if I'm not mistaken. I think it's the second one on the docket, if I'm not mistaken. And so I'm assuming, and I'll get to you, Mr. Domenici, in a minute. I'm assuming that you have been trying to work this out with Select and you're not getting anywhere?
Coterra is in discussions with Select, and if things work out, then that'll be great. And if not, then we're going to maintain our objection.
Okay, Ms. Hardy, anything to say about that?
No, I know Select and Coterra are talking. And
What's the nature of the objection?
Well, I think they have operating, producing wells within the area of review.
Within the half mile?
Yes. And so Select is working with them to try to resolve their concerns.
To minimize any impact on the
Right.
wells?
Right.
Are they vertical wells or horizontal wells?
I think the Coterra wells are horizontal wells.
Okay, well, even if that is resolved, I have a feeling the city of Jowl will still maintain an objection. I know that we denied, and you appeared in front of the commission recently on Desert Ram and Pilot. Mr. Suazo, I see, is still on with us, so I'm sure he's wondering what we're going to do with the intervention of JAL. So, and those de novo appeals are being held in abeyance until the division issues its orders. I wonder, on all 4 cases, is that the idea? I wasn't sure about that.
Well, I think that is right. I think they filed de novo applications on all 4 because they were asking to stay the division proceedings.
Right.
In all 4.
In all
as
4.
well.
Okay, I wasn't sure.
That was denied. Right.
Okay. Mr. Suazo, is that your understanding of the commission's ruling, is that your motions to stay and your intervention is being held in abeyance until all 4 orders are issued?
Yes, Mr. Examiner, that is my understanding. And, I'd like to go back and read the transcript just because, the discussion was kind of scattered. But, I think the point is that once these division cases are concluded, then Pilot and Desert Ram still have the ability to basically, have a hearing in front of the commission. I did ask if there's the ability at your discretion to be able to play a bigger role on the underlying proceedings, but, that wasn't really, I don't think addressed and no conclusion was reached.
And I see Mr. Sayer here as well. Mr. Sayer, what did you understand the commission to rule about? Is it all 4 cases or is it just the 1 case? And I'm not sure which, if you sought to intervene on all 4 cases or just 1 case.
Yeah, Mr. Examiner, it was all 4 cases.
Okay, and what was your understanding of the commission's order?
The same as Mr. Schwazo's and yours, I believe, that the applications are being held in abeyance pending a decision from the division.
Pending a decision on all 4 cases or just this one last case?
I believe it's each case.
Okay, all 4 cases. All right. Okay, all right. Because we probably will have orders on 3 of the cases long before this last case, because I'm sure they're working on them now, but I'm not involved in that, so I don't know. Okay. So let's see. We have a hearing on June 2nd. We've already said that. And we have a motion to intervene, or it's a notice of intervention. We have a motion to strike the intervention. We have a last minute response from Mr. Domenici. I have had an opportunity to review all of them before I came down today. So let's deal with this motion and response now.
Mr. Examiner, so sorry to interject. One more entry of appearance,
Do you?
please.
I didn't know that.
Carrie Hatley entering her appearance on behalf of COG Operating, and we are monitoring only.
Thank you, Ms.
You are very welcome.
Should have seen that. That was the first one on my list. All right. Mr. Domenici, I did have a chance to review. I do have some questions for your witness. I did ask Freya to put you on notice that I might have some questions for your witness that I knew about at the time. Ms. Hodge?
Yes, and it's, yes, Ms. Hodgins, and she should be available.
That'd be great.
And, she worked very closely with another geologist in her office, Paul Dracos. And he wasn't available to prepare that notice filing, but he is available to testify today.
I don't have questions for him. I just learned about him literally minutes ago.
Okay.
Along with another witness from the city of Gel. I forgot their name.
His name is Stephen Aldridge. He's the recent mayor. He's not the current mayor, but he's consulting with them now on their water resource issues because he's been so involved the last 8 years. So he's available also.
Okay. So Ms. Hardy, it's my intention, so I've reviewed your motion, obviously, carefully. And the response and the notice of intervention with the attached affidavit from Ms. Hodgins. Do we have Ms. Hodgins with us? Mr. Domenici? There we go.
I am here. I'm just sharing a camera with Paul Dracos, so we're both in the same office.
Very good. Would you please turn your camera on?
Yes.
There we go. Hello, good morning. Let me get you sworn in. Would you raise your right hand? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you. Would you put your hand down and spell your name?
My first name is Megan, Meghan. Last name Hodgins, Hodgins.
All right, very good. And I don't remember, oh, yes, I do remember. You, in your self-affirmed statement, you said that you had been qualified as an expert before, what is it, the Office of the State Engineer?
Yes, in water rates hearing, yes.
I'm sorry, as what?
An expert in, I'm sorry, let me double check what the wording was. Hydrology and groundwater modeling
Okay,
is in a OSC water rates hearing.
all right. Well, we have not recognized you as an expert in that field. And I don't know if I need to deal with that today or not. I have some questions that I'm going to ask Mr. Domenici first, and then I'll have some questions for you. I'll also allow Ms. Hardy to cross-examine you. And if I need to admit you as an expert, then Ms. Hardy will have an opportunity to challenge that through a voir dire process. Mr. Domenici understands that as well. Okay, so Mr. Domenici, in reviewing your notice of intervention, some questions I just want on the record, okay?
Certainly.
So Select states in their motion to strike that the city owns no wells and has no proprietary interests within the half-mile AOR, area of review. Is the city disputing this factual assertion?
We do not have it. We don't have any well bores within that half mile. We would capture water within that half mile through our wells. We have 2 high volume permitted wells that are the heart of the future of our well system, that are the closest 2 wells to the Coyote well. They would highly likely capture water from within that half mile, but the well bore itself is not within the half mile.
All right. So let me be clear about how I'm considering your statements. That you're not an expert in water hydrology, et cetera. So when you say it's highly likely that the wells will capture water within the half-mile AOR, I'm going to take that with a grain of salt.
My experts are prepared to testify to that. We've had to do modeling in order to permit those wells. The modeling shows the effects. The model's recognized by the Office of State Engineer for that part of the state. It's utilized by all water operators. So it's very fundamental, that statement I'm making. I'm not an expert, but I've been dealing with JAL's well system and protests, et cetera, for about a decade. And these are 2 extremely valuable. These wells are the future of JAL, and they're very proximate, but they are, strictly speaking, slightly outside the half mile.
Okay, perfect. And this is not the evidentiary hearing that's going to occur on June 2nd. I just want you to know that. So really, these questions are for the purpose of either granting the intervention or denying the intervention based on the motion to strike and your response. Okay, so I just want to make sure that you understand we're not having the hearing now.
I understand.
All right. Your objection, because you filed a notice of intervention and an objection. Your objection references future permitted groundwater wells located 1 mile from the proposed saltwater disposal and 4 existing wells 2 miles away. How does the city contend that interests outside the half-mile AOR satisfy standing under 1915-411 or 1915-26-8 NMAC?
Certainly. So just to be clear, the 2 wells that have not are not producing, they are fully permitted, and they are in the budget. There are pipelines that have already been designed, funded to pipe that water from those 2 new wells to a central location and where all of our wells pump water, and then that water is piped 8 miles to JAL. So we have had to establish a well field in what is called the JAL Basin, a very small basin that was established to protect JAL's water rights. And the water in that is the PVA, and that is also pretty small and fragile. But these 2 wells were located specifically because there is a trough that provides the best source of water as sort of at the edge of the PVA. That's called the Monument Trough. And so we worked extensively to overcome protest, to acquire the land rights and the easement rights to locate these 2 wells where they will be highly preferable to our existing wells. And they will certainly have a very wide range of impact because we're going to pump both of them to our well system and rely on them into the future. So for standing, we think we meet the element of public health and the environment. We're not contending this is correlative rights or waste, that more of an oil and gas world, but the water supply for a municipality and the resiliency of that water supply is an absolute matter of public health. It's the highest priority for this particular community. We have had a prior well field completely destroyed by surface contamination from oil and gas operations, drilled through that well field that was to the opposite side of JAL. We had to acquire a section of land from the state land office to totally relocate our well system. And then we've had encroachment on that well system by numerous production wells, frankly, for oil and gas. And we've had to lease additional acreage. We've traded additional acreage. We've kind of acted down there with water, like some of the oil and gas matters that you see here. That's been kind of what's been taking place with water down there. So we've had to protest, we've been protested, and we've acquired the future of JAL is these 2 wells. They will be drilled, they will be high volume, they will be successful. We've already done a drill hole to establish that they will be successful. And we value and we're worried any contamination into the PVA will spread throughout the PVA.
What is PVA?
Pecos Valley alluvium. So it's an alluvial aquifer that does not appear everywhere over by JAL. It appears only where there is collapse conditions allowing that alluvium to hold water. And when you find that, you're able to extract it at pretty high volumes. If you go to the next lower aquifer, which is the Santa Rosa, it's much more precarious to find water and be able to extract it. So this is precious, precious water. We are also competing, unfortunately, with the state of Texas, who is pumping on the PVA pretty hard. And so that's why we located these wells in a location that protects us from Texas's pumping, as well as other users, as well as, and there is interplay between the Santa Rosa and the PVA, that well established, recognized. So these, for the public health and environmental protection of the city of JAL, we want to be sure what we want to do, and you clarified, this is not the public hearing, or this is not the hearing, but we want to participate in that hearing. We want to cross-examine the geologic experts, which we don't really get the opportunity at a standing hearing, to fully explore their knowledge, because we think our 2 experts have extensive knowledge. We have had to pay literally millions of dollars to study this aquifer and to engage in hearings that have gone all the way through hearings to de novo hearings in district court. The process is somewhat similar to what you have over here in the state engineer world. And so we have all of that knowledge. Using that knowledge, we located these wells. We have other wells in the PVA, and we know very much about the Monument Trough. We have concerns that the Monument Trough indicates there are faults below and related to the Monument Trough, that the pressure that will be injected could exacerbate those faults that we are aware of, and could allow the disposed water to percolate upwards through faulting and cracking into the Santa Rosa, which we may or may not actually be right where we don't know the Santa Rosa as well as the PVA, but the Santa Rosa underlies most of the Jowl Basin. It may not underlie exactly where these two wells are, but if it gets into the Santa Rosa, there's an interplay between those two aquifers, well recognized, and it will then get into the PVA. So we feel it puts our entire aquifer at risk, these wells, but we have two wells that are most proximate that we think really meet the standing requirement. We think there is, we are concerned about actual injury to our sole source of the PVA aquifer through faulting and geologic conditions that would be impacted by the high volume, high pressure activities proposed at relatively low depths in comparison to other disposal wells in our vicinity.
All right, thank you. I have 3 pages of questions here, and if each answer goes on that long, Mr. Domenici, we're going to be here all day. I understand your knowledge, it's extensive, and your passion for the subject, that's obvious. So I might be able to skip some of these questions. Let's see, my next one talked about the city states that its wells might be affected by the proposed SWD injection. What evidence transforms this hypothetical concern into a concrete and particularized injury as required under the standing framework referenced in the motion? Can you answer that or pick something that you've already said and just give me a sentence there?
I think I've already stated it. It's the monument trough, which is shows a history of fractures above the injection area. There's faulting that is documented,
Okay,
and it's the
I got it.
combination of that geology.
I got it. I got that from what you just said a little while ago.
That's it.
I thought I heard that, but I wanted to make sure. Does the city have any hydrological or geophysical study contradicting Select's conclusion of 4,265 feet of vertical separation and multiple confining zones between the injection zones and the USDW? And I wonder if I should ask that question to Ms. Hodgins. So let me direct that question to Ms. Hodgins.
We don't have sorry, not sure objection is the right word. We don't have a disagreement with what the depth is. The study that we did, we were primarily looking at the drinking water aquifers. So we're mapping out faults in the that go through the Santa Rosa, Dewey Lake, and through the Rustler Formation in the work that we did. And the problem that we have is the fact that the SWD is in close proximity to the faults that we mapped out during our investigation of the Jowl Basin. These faults were caused by collapse of the monument draw trough, and the faults and related fracturing can create a pathway for contaminants to come up into the drinking water formations. There is separation, and if the formations are completely competent, there may be the containment, but our concern is that they are not competent because they're in this area where the ground has been faulted, due to the collapse of evaporates below the Rustler Formation, which includes the Salado and the Castile formations, which are part of that separation. The faulting and collapse of these from the dissolution could take it right down to the top of I should say the bottom of the Castile Formation, which is directly above the Bell Canyon Formation, and could potentially reduce the amount of confinement in that area. and if the small amount of remaining confining layer there under pressure of the injection into the Bell Canyon, if that confining layer at the top of the Bell Canyon fails, it could easily go up into the already existing dissolution up through the fractures and eventually make its way up into the drinking water formations.
All right, thank you. Mr. Domenici, let's have a question about zone of interests. The commission's Hill Court precedent, which is order number R 10987-A2, held that generalized fears of groundwater contamination fell outside the zone of interest for density related permitting. This was one of the issues that I had with Desert Ram, which was another potential intervener into this case, which I denied. Okay.
Yes.
How does the city distinguish its concerns from those rejected in that Hill Court case?
Several things. First of all, we think we have more information about the geology and the difficulties with and concerns about these confining layers than perhaps Desert Ram may have had. We have what information we have. We've been looking at this for a long time. We've had to study this particular application pretty quickly, but we've relied on information we've developed over a series of years. We don't have generalized concerns. We have the sole source aquifer for this community that it's not and I don't like to necessarily weigh different uses of water, but an irrigation well is a lot different than the sole source aquifer for a municipality that is diligently struggling to have a resilient water supply for decades and generations, frankly, out into the future. So we don't think the Hill Court case is, from our view, is quite different. It's not there's not a municipal water system at issue. There's not a disposal well that you're talking about. So I think there's a lot of differences from Hill Court. Desert Ram, frankly, is more similar because it's the same exact case. They have a well into a similar aquifer, not a whole series of wells, not a $25 to $30 million water system like we have, but they do have similarities in terms of their well and our wells. We frankly just think that we take more water. We have a much larger water right than they have. We have a much larger well system. We have all the other infrastructure that goes with that. And I don't want to weigh their experts with ours, but we have capable experts willing and able to provide testimony that meets the standard that there is an actual threat of injury.
Okay, thank you. Let's see. A lot of these questions you've already answered. That's why I'm not asking them. When did the city first become aware of the application that was originally filed in August of 2025, refiled January of 26? And does the city dispute the timeliness or adequacy of Select's notice?
We became aware from it from one of the parties in the case. I want to say maybe a month ago. There seems to be in the record a reflection that there might have been a phone call to someone at the city that never made it to the mayor at the time, now the water consultant, who would have triggered the activity that we're engaged in with our consultants and attorneys. So I'm not able to say if that phone call took place or not, but we have not seen any written notice at all. And we received notice that we were able to act on within about, I would say, 4 weeks.
Does the city contest Reed Davis's sworn statement that Select conducted a diligent search and that no unlocatable parties exist?
We don't contest that.
Miss Hodgins, Did you review Select's C-108 attachments, including the AOR maps and hydrologic analysis showing that no pathway between the injection zone and the USDW?
Yes, I reviewed that.
You did, all right. What's specifically in those materials are you disputing?
Excuse me. What we're disputing is the competency of the confining layer and the proximity to the faults. I believe they're less than a mile from the basin bounding fault on the western side of the Jal Basin. That was not taken into consideration as a potential source of or creation of a potential conduit.
Okay, perfect. Thank you. That was a succinct answer. I appreciate it. What methodology did you use to determine the possibility of an aquifer impact?
Methodology? Is that what you
Yes,
said?
I did.
Yeah, we did an extensive analysis of the Jal Basin using available gamma logs primarily from oil and gas wells, and also wells that the city drilled as part of their exploration project for their water system. We have a series of cross sections, north to south, actually east-west cross sections and north-south cross sections that cover the area of the Jal Basin, which is just to the east of the Coyote well location. Can I share a screen to show this, or is that?
No, that's good enough. These questions are just supporting my ultimate ruling. So no, that's fine.
Oh,
That's good enough
okay.
for now, but obviously you'll want to do your best if we do get to a hearing with your participation. Are you aware of any data indicating a hydraulic connection between the Bell Canyon, Cherry Canyon formations and the aquifer supplying the city wells?
There is no study of that connection.
Okay, thank you.
It's just based on the information that we have that there is a potential for it.
Those are the questions I have for Mr. Domenici, and your witness. I'm going to open this up to Ms. Hardy for cross-examination.
Thank you. Ms. Hodges, a couple questions for you. First, you're not an engineer, correct?
No, I'm a geologist.
Okay, so you don't have experience or training in reservoir engineering or drilling engineering, correct?
I am not an engineer of any sort.
And have you ever testified regarding potential impacts of a saltwater disposal well?
I have not, no.
And have you ever performed any studies on saltwater disposal wells?
Not on saltwater disposal wells. We work with drinking water. We've done extensive work on drinking water wells.
And do you have any experience modeling saltwater disposal well injection plumes?
No.
Regarding your statement that was provided, you don't reference or discuss the analysis in Select C-108, do you?
I'm sorry, can you repeat that? I didn't.
Sure. Your statement doesn't discuss the analysis that's provided in Select's C-108 injection application, does it?
No.
And you testified earlier that you have looked at the aquifers, right?
Correct.
And I think I heard you say earlier in response to the hearing examiner's questions that you did not evaluate the confining layers above and below the injection interval. Is that correct?
No, we did not evaluate those layers.
And you haven't modeled the injection plume for this saltwater disposal well, have you?
No.
You stated earlier in response to the hearing examiner's questions that if the confining layer fails, that injected fluid could migrate. Is that correct?
That is correct.
Your statement that you provided, as well as your testimony here today, let me re-ask that. It's going to be confusing. Your statement that you provided does not contain any conclusion that to a reasonable degree of geologic certainty, there will be communication between the injection plume and the city's wells, correct?
No, we were just discussing the potential that it could happen.
Okay. And looking at your statement, a couple of questions for you. And I am looking at paragraph 6. And in paragraph 6C, you state there are likely additional faults, correct?
Yes, this is referring to the cross sections which are attached to the affidavit, mapping out the approximate location of faults based on our basin analysis. And in our analysis in the cross sections, we show one fault on the west side based on the location and information in other logs on either side of that fault. But there's possibility the location of that fault is not exact. We just know that it's in between where we had data.
Okay, so you haven't determined with certainty that there are additional faults in the area, right?
That is correct.
And in paragraph 6D, you state that faults near an SWD well are potential conduits for upward movement, correct?
Yes.
And you state that fractures associated with faults may extend beyond the location of the mapped fault, correct?
That is, yes, that's what it says.
And then in paragraph 6E, you state that there is a possibility of interconnection between the formations, correct?
Yes.
And then in paragraph 6F, you state that injection could potentially cause migration, right?
Yes.
And then in paragraph 6H, you state again, there is a potential for contamination during drilling, right?
Yes.
Okay. But again, you're not a drilling engineer, correct?
I am not a drilling engineer, but I've been on many drilling rigs during drilling of water wells, and I know there's always a potential for contamination of those sites.
Okay. And then in paragraph 7A, again, you state there's a potential for contamination, right?
Yes.
7A. Okay.
Yep.
And you make similar statements throughout the rest of those paragraphs under 7A, right?
That is correct.
Okay. Those are all my questions. Thank you.
Are those your questions?
Yes.
All right. Mr. Domenici, this is not a hearing, so I'm not going to give you an opportunity to redirect your witness. This is not the point of this. I asked questions. Ms. Hardy had a right to cross-examine the witnesses. I've drafted an order in which I have my findings of fact, my conclusions of law. I'm not going to read all the findings of fact. They do include your response. So it's up to date and it's ready for my signature. But I will go through the conclusions of law because I think, number one, it's much shorter. And I want the parties to understand why I'm coming out on a different side than I did with Desert Ram and with Pilot. I feel it's premature to strike the city of JAL's notice of intervention because I think the division would benefit from their participation. In other words, I think that they could contribute substantially to the prevention of waste, protection of correlative rights, or protection of public health or the environment. I understand that the assertions are at this point, there's a word that Justice Scalia used in one of those cases in which it changed how you could get in the court door. And I think it was changing it from a scintilla of evidence to something that's plausible. So I think I've come to the conclusion that the city has a plausible injury in fact, or a potential injury in fact. That's a word I'm using because I can't think of any other better word to use. I realize that under 1915-411C, a notice of intervention may be struck if an intervener fails to show standing, unless the intervener shows their participation will contribute substantially. And I'm willing to give the city that opportunity in this case. Select has raised substantial arguments questioning whether the city can meet the civil law requirements for standing, including injury in fact, causation, and redressability. The city has also raised substantial arguments that the half-mile AOR in 1915-26 8B2 relates only to mailed notice, not to standing, and that the order relied upon by Select was overturned. The city has now identified 3 witnesses whose expected testimony addresses hydrologic modeling, groundwater vulnerability, previously unidentified faulting, historical contamination of city water supplies, and potential catastrophic consequences for public health and safety. The city's new evidence, including the Aldridge affidavit, raises technical and factual issues that the division has not yet evaluated through testimony or examination. Given the threshold nature of the motion and the discretionary standard in 1915-411, striking the city's intervention at this time would be premature. Allowing the city to remain as a limited intervener will ensure the division has access to all relevant testimony that will not prejudice the parties or delay the proceeding. If Select wants to renew its motion to strike at a later time, if the city's testimony is shown to lack technical basis, exceed the authorized scope, or fail to contribute substantially to the issues identified in the rule, they may do so. But at this point, the city of JAL shall be permitted to participate as limited intervener for the purpose of presenting evidence, testimony, and argument related to groundwater protection, hydrologic conditions, environmental impacts, and public health and safety within the scope of 1915-411. You know, Mr. Domenici, that hearing is scheduled for June 2nd.
Yes, I understand that.
And your witnesses will need to be available. Now, you need to be here. Your witnesses can be virtual if they so choose.
Okay,
Are there any questions, Mr. Domenici?
no questions.
Are there any questions, Ms. Hardy?
No, thank you.
All right. Well, thank you for everyone's participation today. I think that concludes, oh no, Ms. Vance has her finger up.
Of course. I just wanted to confirm that on those Corby cases, case numbers 26008 and scratch that, 26057 and 26058. Just confirming we're good for the August 6th and 7th date.
Oh, you're confirming, good.
Yeah. Mhm.
August 6th and 7th, you said? That's good.
Correct.
Okay, and I think we were looking, was it Ms. McLean?
I haven't heard
Okay.
anything back yet, but I did have another question,
Yes.
unrelated. You said that because of the June 2nd hearings, that the June 4th docket was going to be more like smaller than usual. Do you know when you'll know what the cutoff? Because, we have a substantial amount of exhibits due next
Oh, you
week.
do?
And with the holiday weekend and everyone here's birthdays, we would love to have some direction.
Good point, good point. Okay, that's well taken. Ms. Chance, at this time, if I'm not mistaken, aren't there like 90 cases on that docket?
I believe so. I'm pulling it up now.
That's what I remembered from earlier in the week.
I can tell you, we're going to be continuing some.
Oh, you will? Okay. Well, good. Thank you.
Yes, there's approximately 90.
Okay, and I was talking to Mr. McClure. We have limited technical advisors for that docket because of other commitments with Mr. Garcia and Mr. Fordyce. And Mr. McClure is also the technical examiner for the cases on the contested docket on the 2nd of June. Freya, who's in the number one position on June 2nd?
It's a Powderhorn hearing. I don't have the case number handy.
Ms. Vance, you're nodding. Does that mean that's your case?
Yeah, so we're representing Matador, Miss McLean and Miss Hardy are representing Powderhorn.
That's right. And that's why I continued that case from May. Good. So Miss Hardy, Miss Vance, though that Powderhorn, I'm sorry, Patera?
We
What
represent
did you
Powder
say?
and Ms.
You're
Vance
Powderhorn.
represents MRC.
MRC. That case is still moving forward?
It is at this point, yes.
Yes.
It is at this point. Okay. All right. Well, that's number one on our docket. So then we'll have the 3rd of June for select. So Mr. Domenici, just so you know, we may not hear it on the 2nd, depending on what happens with this other contested case. It may be on the 3rd. But one way or another, it's going to be heard that week, even if we have to hear it on the 4th or 5th. I mean, that's why we give ourselves this leeway. So please let your witnesses know to be available. Yes, of course. So with that being said, now normally our docket is limited to about 50. Okay. Based on the other, and Mr. McClure is also going to be involved in the select case and the Powderhorn MRC case. I have a feeling the docket will be somewhere between 30 and 40 hearings by affidavit. I don't know that we have a list yet on which cases. I think it's the cases that got bumped from the last docket go first on this docket. So I don't know if you know what those are or not, and I don't either. Freya, is there any way to give the parties any idea what the first 30 or 40 will look like?
I can distribute the docket tomorrow. I was just waiting for kind of what the total would be so that I would know how to make
Does that help?
the cuts, but
That's very helpful. Freya, that would be really helpful if we could cut that down to, let's say, 40. And then I've spoke to Mr. McClure this morning and said to him, if you can't get to some of them, then we'll just have to continue them. We don't like doing that, but at least you'll know which ones we're definitely not hearing. Yeah. And, based on our availability, we may be able to add, since those cases will be noticed, we may be able to add something toward the end of June. Freya, it's my understanding that you sent out some dates for special dockets in later June, and no one seems to really want them. Is it possible that we hear the rest of those cases later in June?
we could on June 23rd or the 30th.
So we have some options here so that we can move cases along. We haven't spoken to technical yet, so I don't know that yet. But let's make some decisions after we survey the docket, get out the 40 cases. We'll try to hear June 4th, and then I can talk to technical next week or so to see if they would be open to having another hearing by affidavit docket to clean up those other cases that we don't get to. That work for you?
I have 3 cases that are time sensitive.
Yeah.
And so I just want to make
Good.
sure that, and I know I'm going to be continuing some other
Yes.
cases. So if I can give those to Freya to just make sure that I get at least these 3.
Figure, why
On the
don't you talk to Freya after the hearing is over? And I think we are, unless you want to say something else, I think we're done.
No, I think we're
You're
done.
good?
I'm good.
Ms.
I
Bennett?
don't.
Nothing
We're
further from
good?
me.
Ms.
Thanks.
Hatley? All right, excellent. All right, Mr. Domenici, we'll see you here in Pecos Hall on the, well, whatever day it will be, 2nd, 3rd, 4th, who knows? Thank you. We're off the record.